How should the trial judge instruct the jury regarding the burden of proof on the issue of consent? Um, I'm just going to read the answers. A, the defendant must prove by a preponderance of the evidence that the victim consented. No,
Why is no?
because on the defendant to prove, it's on the prosecution to prove.
Okay, and when is the defendant need to prove anything?
The burden shifts like for insanity, I believe.
Right.
So, I mean, can I go ahead and just cross out BC? Because
I don't know. Read it. I don't know. Don't jump too fast.
B, the defendant must prove by clear and convincing evidence that the victim consented. No, clear and convincing is for like family law, probate, and to a rebuttable presumption. And then C, the defendant must prove beyond a reasonable doubt that the victim, no, prosecution must prove beyond a reasonable doubt. D, the prosecution must prove beyond a reasonable doubt that the victim did not consent. Yes, because it's an element of the crime. Consent usually, right?
I don't know. Well, now go ahead and read the facts.
I circled it, but.
See, no, you circle it and see if the fact mandate with D.
So a state statute provides as follows. In all criminal cases, whenever the U.S. Constitution permits, the burden of proof as to a defense claim by the defendant shall rest on the defendant, and the magnitude of the burden shall be as great as the Constitution permits. And that's in quotations. I'm going to put a little box. The same state defines the crime of forcible rape as follows. Forcible rape consists of sexual penetration inflicted on an unconsenting person by means of force or violence. Consent of the victim is a complete defense to a charge of rape. At a defendant's trial for forcible rape, he testified that the alleged victim had consented to having sexual intercourse with him. How should the trial judge instruct the jury regarding the burden of proof on the issue of consent? So it's defined here. It says the same state defines a crime as a forcible rape, and then I forgot to put little boxes around this. So here's our definition. Forcible rape consists of sexual penetration inflicted on an unconsenting person by means of force and violence. Consent of the victim is a complete defense to the charge of rape. So D, the prosecution must prove beyond a reasonable doubt that the victim did not consent. And I like that because in the definition of the statute, it says inflicted on an unconsenting person, so it's an element of the crime, and a complete defense.
Okay, you totally miss the purpose of this lecture. The purpose of this lecture is the state statutes.
Oh, okay.
So that tell you if they jump away from common law. Then the next question is, you go ahead and skim through where the statute is.
Okay.
So you found the statute, right? You found the statute. Foreseeable rape consists of sexual penetration, inflict of non-consenting person by meaning of the force and violence. Right? Consent of a victim is a complete defense to a charge of a rape. So that's how you're gonna do from now on when you see they give you a statute. go find the statute. Everything here is a waste. Go find the statute, see it, and apply the statute, okay? And then call the questions. And that's the lesson of today is the fact pattern gave you a statute, go find the statute and apply the law and put in your brain that is not common law, okay? So here is D. Which your analysis is correct.
D.
Go ahead.
D, correct. The state statute includes lack of consent as an element of the offense. Due process requires the prosecution to prove beyond a reasonable doubt all the elements included in the definition of the offense of which the defendant is charged.
Okay. So this one is, it doesn't ask you, it's kind of like who have the burden of proof. And we know that the state has it. We know that. But this one is going to teach you that, it's teaching you that all elements, they always test you on it. Every element in the statute, the state must prove beyond a reasonable doubt. It must prove, well, what is all the elements? Well, that's the whole statute. The one that they go, right? And all those elements, it must be proven. So they're kind of messing you up. Normally, a statute will stop here. We stop here. It will stop here. Right? Normally this is going to be a quote right there. But this one, it has another element, consent of the victim is a complete defense to a charge of rape. So then they have to prove also that she wasn't consent to rape beyond a reasonable doubt. The prosecutor must prove beyond a reasonable doubt to the victim consent. So it teaches you this element, the next sentence of the statute.
I thought it was because of the other part within the statute, this part, the unconsenting person.
Talking about which part?
This part. Now,
no, they test you on this part. They test you on the part that I told you.
Okay.
Now, see, normally it's N here. But then it has this one. So this one is inside the code, inside the statute. That is an element also.
Let me ask you one thing. Okay, so you said because it's a statute, it's not common law, right?
Correct.
So under the common law, say this was under the common law, would the burden of proof shift to the defendant, like in the insanity, as far as for consent?
No, it's proved. It's shifted the proof that he have a defense. If it's common law, the defendant got to prove that the woman consented. If it's common law, it's a defense. It's like everybody, you know, like a whole bunch of Hollywood people right now, they raise, no, she consented it. Right? It's a consensual sex, no rape. You know, there's some people tie other woman up, you know, do all the weird stuff. And now she said, well, he tied me up, he raped me. No, 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 no. She consented. This is how we have sex. But that's common law.
Common law would shift the burden to the defendant.
Yeah.
Okay, that's what I wanted to know. So when I see it, can I apply the opposite of common law?
That's right. Okay, so in common law, the defendant must prove preponderance of the evidence that he was insane. Also, he had to prove by the preponderance of evidence that the other party consented as a defense. Okay, if he raised a defense, then he had to prove preponderance of evidence. Here, okay. Any, oh, I got out. Okay.